Well, hello everyone, and welcome to the part two of our judge series. We're talking with Lisa Middleman, who is a candidate for Court of Common Pleas, and Hilary Wheatley Taylor. She is a candidate for the magistrate seat here in Mount Lebanon, Dormont. And we have Laura Perkins, who is with Casa San José. And we want to welcome our guests. We're talking about the courts and the police. Welcome, everyone.
Hi, thanks for having me. It's nice to see everyone, sort of.
Yeah.
Hi, everybody.
All right. So we are here and we have the two candidates and Laura Perkins from Casa San José. And why don't you go ahead and you just said hello, but why don't you introduce yourselves and tell us what you are running for and a little bit about yourself. Lisa, you are at my top left. So why don't we start with you?
All right, my name is Lisa Middleman. I am a 35-year public defender. I do homicide and death penalty cases for the Public Defender's Office now. And I'm running for Court of Common Pleas of Allegheny County. There are actually 9 open spots, and so I'm hoping to get one of them.
All right. Hilary?
Yeah. Hi, I'm Hilary Wheatley Taylor, one of 2 Hillarys on this webinar tonight. I am the candidate running for magistrate in Mount Lebanon and Dormont. I've spent 18 years as a civil litigator in the courts of Pennsylvania, and the magistrate seat in Mount Lebanon and Dormont is open following the retirement of longtime serving magistrate judge Blaise Laratunda.
Okay, and Laura, why don't you introduce yourself?
Hi everyone, my name is Laura Perkins. I'm the emergency response organizer at Casa San José. We're a Latino and Latina nonprofit here in Pittsburgh. So I respond to family separations, ICE detentions, and police detentions in Pittsburgh.
Great, great. All right, so we are here, as Stephanie said, we're on the second speaker series, and this one is titled The Police, District Attorney and Our Courts, discussing this very tricky interplay of these 3 entities. So what we're going to start with, we like to always kind of give a little bit of background. We're going to start with a PowerPoint here, giving some arrest stats. And I'm going to go ahead and start with some statistics on arrests. This is from a study completed by Dr. Ralph Bangs of the Center of Race and Social Problems at the University of Pittsburgh. It's called Black, White Disparities in Arrests in the City of Pittsburgh. It was from February 23rd, 2021. And what he found is that the number of African-American males arrested in Pittsburgh by Pittsburgh police in 2020 was 3,883 compared to the number of white males arrested by Pittsburgh police in 2020, which was only 1,746. And what we know of the population of Black males to white males is obviously that these numbers don't add up because there are significantly more white males than Black males. Looking at the number of African-American females arrested by Pittsburgh police in 2020, the numbers were 1,220 compared to the number of white females arrested by Pittsburgh police in 2020, which was 733. Now, these numbers actually look worse when you then look at the bottom point on this chart, which is those arrest statistics show that 11.7% of Pittsburgh's Black population was actually arrested in 2020. That number is kind of staggering when you think about that over 10% of Pittsburgh's Black population was actually arrested in the year 2020. Showing that Black males are not only arrested more than white males, Black males are frisked during traffic stops 9.9 times more than white males. Black males were 9.2 times more likely to have field search or warrantless search and seizures than white males. And these were all based on the statistics during 2020 as found by Dr. Bangs in his study. So starting with you, Lisa, you've been doing, criminal justice work and, criminal defense work, for a really long time. Do these statistics surprise you in any way?
No, I don't find them at all surprising. Those of us who work within the criminal legal system, have known this for a long time. People of color are disproportionately overrepresented in the criminal justice system because the communities in which they live are over-policed. They're over-policed. Systemic racism in arrest and charging procedures also affects the number of Black people who are caught up in the legal system. There's a lot of implicit bias that is shown by not only the police, but judges, prosecutors, and making charging decisions. So those of us who work in the system understand that this has been a fact of the legal system for a very long time. There are, of course, ways that we could try to change this. There aren't very many African-American police officers in the city of Pittsburgh. People are not required to live in the city of Pittsburgh in order to be a police officer. And I feel like all of those factors make it much more likely that this type of behavior will continue.
Okay. And Hilary, we know that Mount Lebanon, your community, recently released statistics on police stops within its own community. How do these statistics compare to kind of the statistics that were found based on the police stops in Mount Lebanon?
That it's just blatantly disproportionate. The numbers are, and the way Mount Lebanon records stops is by calling it contacts. And so their records indicate that their contacts for the year in which the data was released were that 13% of the police, 13% of the contacts were with people of color. And yet only 1% of Mount Lebanon's population are people of color or Black people. And then, we've got 92% white, 1% Black, 4% Asian, about 2% Latino, Hispanic, and yet they're interacting with 13% of who they interact with are Black people. And so that in and of itself is just blatant disproportionality. And there's no explanation for it based on the population.
Okay. All right. You're on mute.
Sorry about that.
Right.
Going into warrantless stops, whoever would like to answer, just so we understand how we end up with statistics showing such high numbers of disproportionate warrantless searches and stops of Black men. Can you explain what would entitle an officer to be able to do such a search under the law? Lisa.
I can field that one. So most of the time, and we all know the Fourth Amendment prevents unreasonable searches and seizures, but and most of the time when police officers want to do a search, they're required to go get a warrant, a search warrant. And we've all heard of those. But really what that is any place where you have a reasonable expectation of privacy, like you have a reasonable expectation that your home is private. You have a reasonable expectation that, your car is private. So if they want to search those things, they have to get a warrant, unless these search circumstances fall under what they call exceptions. They're exigent circumstances. Like, these are reasons why we just don't have time to get a warrant. And one of those reasons is, like, we're pursuing a fleeing suspect, so we don't have time to get a warrant to seize him. If he's running away from a crime, we don't need a warrant to seize him. Or, I'm in a grocery store waving a gun around and the police want to come take the gun from me. There's a sense that I have to do that right now. I can't wait to get a warrant. Or to prevent the imminent destruction of evidence. So if I go get a warrant, your evidence is going to be gone or disappeared. And so that's where a lot of these street contacts come in. Like, the police, there are different levels of encounters with law enforcement and different levels of scrutiny, so to speak. So a mere encounter with a police officer just means, like, you're walking down the street, they're walking down the street, they stop and talk to you like, hey, what's your name? Or what are you doing around here? And they call that a mere encounter. And the police don't have to have any suspicion of you, and there's no legal requirement for them to engage in a mere encounter with you. And you're free to walk away from that at any time you like. There's also an investigative detention, and that's not something that you can walk away from. An investigative detention means that the police officer is asking you to stay there and can hold you there for a short period of time, but they have to have reasonable suspicion that a crime is occurring or that you're armed and dangerous. And so that basically subjects you to a short period of time, but it doesn't have the horribly coercive conditions that, like, an arrest would be, where an arrest is you're absolutely not free to leave and they have to have probable cause that a crime has occurred and that you're involved to arrest you. So most of the time, what happens is the police engage in a mere encounter and then try to develop that reasonable suspicion that you're involved in crime during that conversation. So they may stop and talk to somebody on the street and say, hey, what are you doing around here? And then they will notice that an individual appears to be fidgeting, or an individual is holding their hand next to the right side of their pants, and that might indicate that they have a weapon. And there are almost, like, there's almost a list. If you do this work long enough, there's almost a list that is coming. When a police officer testifies that they stopped an individual and searched them and found a gun, because they use the same phrases and the same wording all of the time. So I lost track of what your original question was, because I got all involved in talking about how these encounters occur. But that's how it happens, generally speaking. The police try to initiate an encounter because they're suspicious of somebody. And a lot of times they'll say, I just had a gut feeling, so I went up and I talked to him. And then they try to develop that probable cause that they need to actually do a full out search. There's a stop and frisk also, which is different from a search. A stop and frisk is that investigative stop, which is the case of Terry versus Ohio, gave the police the right to do, which, if they believe someone is involved in criminal behavior and they have reasonable suspicion to believe that they may be armed, they can pat them down to see if they have a weapon. Frequently, they will pat people down and they will feel something that is not a weapon necessarily, but that the police officers then have probable cause to believe is drugs or some sort of other contraband, and then they arrest the person. So that's how
much, in terms of being able to get that thrown out, or the additional search thrown out, how much like drugs or like something suspicious does that actually need to be?
It needs to be very close to it. There have been cases where small items that could be any number of things have been felt by a police officer during a pat down, and judges will throw those out because that's a violation of your constitutional rights to then seize the item from you, because it isn't clearly, or more likely than not, an instrument of crime or a proof or evidence that crime has occurred. So, there are any number of ways that police officers can justify these intrusions into a person's, privacy. And they have classes, just like any other profession has classes on how it's to be done and how it's to be justified and how the reports are to be written. Body
Right.
cams.
And they learn over time what the jurisdiction's magistrate expects in terms of the language needed in a probable cause affidavit, right? And they use the right phrases and the right keywords and the right emotion in those documents to get what they want, right?
Right,
Part of
so-
the training.
So when they have an encounter that they actually go to a magistrate and ask for a warrant, they have to lay it all out. They have to say, here's what we're looking for. This is the place where we're looking for it. And then they have what's called an affidavit of probable cause, where they say, well, this is why we think we're going to find it there, and this is why we think it's evidence of a crime. So unlike a murder case, they will get a search warrant to search a suspect's house. And they'll have to say the address of the house, and they'll have to say what they're looking for. We're looking for a gun, or we heard that the person was wearing a red shirt, so we're looking for a red shirt. And then they have paragraphs in which to write, this is why we believe that when we go to this house, we will find this red shirt, and this is how it connects to the crime. And they take this paperwork that they put together and they take it in front of a magistrate. And a magistrate is a good magistrate, reads through it and says, you know what? I understand what you're looking for. I understand where you want to look for it. But what you've written here doesn't make me believe that it's probable that you will find that item at that place. Or the magistrate may read it and say, you know what, you've crossed all your T's and dotted all your I's. I absolutely understand why it is that you think it's probable that that item is there, and they sign the search warrant. Unfortunately, magistrates over a course of time have a tendency to just sign off on affidavits. I've been in magistrates waiting for preliminary hearings and seen police officers come in, and they do have to swear to the facts that are contained in the affidavit. But the judge swears them in, takes the paperwork and signs it and hands it back. And you want to say, wait a minute, you didn't even read that. Like, you don't know whether there's probable cause or not. You're just signing that because you know the officer, and that's a problem for magistrates. And that's why it's particularly helpful to have a magistrate that's a lawyer and understands those requirements.
So what, talking about the magistrates, how can a judge or a magistrate ensure that these stops are not racially motivated and were in fact based on the law? What is the role for the magistrate in making sure that, this is not a racially motivated stop? What can they do?
Well, with a warrant, or with just a warrantless stop or warrantless search?
What a warrantless stop, I guess.
Well, Hilary, do you want to field that one?
Well, I think, they can't do anything on the front end, right? Because those warrantless stops are, two officers walking down Washington Road or West Liberty Avenue or Grant Street downtown, and they just happen to come upon some people, and that interaction turns into a warrantless stop. And so the magistrates on the front end have no way to stop that behavior or determine whether or not it was racially motivated. The magistrate's role is I think and the best sorts of magistrates are skeptical of every single police officer's affidavit of probable cause, no matter whether they've known the officer for a month or 10 years. I think some reasonable skepticism and suspicion of the statements ought to be justified when a department or just an institution is rife with inherent racial bias. I think that it ought to always be in the back of the mind of the judge who's evaluating those statements to form the probable cause.
So when you have an issue where you think the search is bad, where a defense attorney looks and says, well, that search was bad, I'm going to contest it. Unfortunately, the magistrate can't do anything about it because magistrates are not entitled to determine whether or not the searches are good. That's something for common pleas court. And in common pleas court, a defense attorney files a motion to suppress. So what they're saying is, the search was in violation of my client's constitutional rights. Therefore, you should not be able to use what you found in that bad search against my client at trial. And then the judge has a hearing where the police officer testifies and any other witnesses on both sides might testify about the search. And then the judge makes a decision about whether or not it was a constitutional or unconstitutional search.
Okay. So I have this might be a dumb question, I don't know, and maybe you already answered it, but you talked about the relationship between the magistrate and the police, and they may have had this policeman in their court quite often. How would a magistrate or a judge guard against, this relationship that they have? I mean, because it's a symbiotic relationship at some point, correct? How do they guard against just trusting the officer when that's part of the relationship, the trust? How do they just, I mean, is it just a case of, having a specific set of standards, and it doesn't matter which policeman is in your courtroom, you just go through those set of standards no matter what?
That's how I would approach it. That it's a set of standards regardless of the officer. And as opposed to lessening or turning a blind eye to the standards and the law and the requirements because I've known that officer a long time and I've known him or her to be trustworthy in his or her duties. I think that the standards ought to be the standards no matter the length of the relationship or the experience with the officers.
I think it's much easier for a judge in the Court of Common Pleas because when you're hearing cases, you hear from various different officers and you don't develop that same, you're not seeing the same officers over and over and over. But I think it's more difficult for a magisterial district judge who does usually see the same officers. I've been to magistrates where the police officers all hung out like up at the bench with the judge. And so they were like their own kind of crew and everybody else was an outsider. So there are things I think that a magistrate can do to make sure that they don't develop relationships like that with the police. There's really no need for them.
Right. They should not be and are not intended to be on the same team as the police, but all too often give the impression that they are.
There's one of the questions that they ask people when they show up for jury service is, would you be able to evaluate the testimony of a police officer by the same standards that you would evaluate the testimony of any other witness? And that's basically, I think, that should be the attitude or the mindset of every judge, magistrate, juror who's hearing facts on any particular case, is that everybody's testimony is judged by the same standards, like Hilary said before.
Yeah.
Laura, you had mentioned you had some issues that your community faces with regard to, demands on their immigration status and things like that with regard to, police might face, and this might be a good segue for those types of questions. If you can explain first what those issues are and the impact on your community, and then, those questions here.
Yeah, thanks. Southwestern Pennsylvania is currently seeing a rise in immigrant population, especially from Central America and Mexico. And we see, particularly with law enforcement and in the criminal justice system, our community being kind of doubly penalized for their immigration status, because when they do have interactions with law enforcement and those interactions lead to ICE detentions, those are two separate entities that are unfortunately often collaborating. And so that, in addition to also language access, which leads to a lot of confusion and often leads to detention unnecessarily, are issues that the community that I work with are facing. And so one question that I would have for you two is, what could you do in your positions to limit ICE presence and interactions in courts?
I'll start and say that there's no obligation for magistrates to allow ICE officers into their courtroom. There's no obligation for them to notify ICE of a potentially undocumented person having a court appearance. And it would be a policy of my office that ICE is not welcome, absent a federal warrant telling me otherwise. And it certainly would not be a place where immigration status or is a relevant inquiry by any member of the staff or the court in the proceedings.
So thinking about, talking to Laura today, I did a little bit of research just because, my position is obviously the same as Hilary's in terms of cooperating with ICE. I think they're a federal agency and the states have absolutely no obligation to assist them in their duties. But there is a Supreme Court case that says that for the federal government to require the states to cooperate with them in terms of ICE would actually violate the 10th Amendment to the United States Constitution in terms of the anti-commandeering of state resources rule. So I think it's very clear that states and thereby counties and local magistrates have no obligation to cooperate with ICE. There was a county in Pennsylvania that tried to actually ban Immigration and Customs Enforcement from making arrests at their courthouse, and that was overturned. So you can't actually ban them from coming into courthouses. It's interesting because when I was looking at all of this, and Laura probably is a much better person to talk about it than I am, but I saw that ICE policy said that there are certain places that are sensitive locations that they won't go into and make arrests, like they won't go into a church, excuse me, and they're not supposed to, but a courthouse is not considered to be a sensitive location. The problem with that is that there are many victims of crimes, survivors of crimes, that need to come to court in order to testify. And they won't come if they believe that they're going to be subjected to immigration consequences. And, from a broader, more policy perspective or policy related perspective, our communities are not going to be as safe if people are victims of crimes and do not come to court and testify. Because the person that has committed a crime against this undocumented person will go on to commit more crimes against other people unless, there is an adjudication of why this happened and the appropriate punishment or treatment. So we're making ourselves all a lot unsafe. We're making ourselves more at risk of further criminal behavior if we allow ICE to interfere with the workings of our local courts.
Yeah, and even on the civil side, Lisa, I think that in a conversation I had with Monica Ruiz from Casa San José earlier this year, just the fear of, ICE involvement stops our immigrant communities from asserting their right to be a litigant in a civil proceeding, to sue for unpaid wages, to bring their child to court to deal with truancy issues, and to ignore summons to court for a variety of reasons on the civil side. And so, to the extent we can ensure that our courts are safe spaces for the assertion of any rights, whether it's a crime victim or someone who has a civil claim, I think.
We're going to have hungry children because undocumented people can't go to court to assert their right to support their children, or get divorce, or visit their have visitation rights. So we're making our communities less safe if we allow ICE in our courtrooms and in our courthouses, I think.
Yeah.
Yeah, and another way that Immigration and Customs Enforcement can get information and do their work is through often unintentional data sharing. And so by recording immigration status, because sometimes we just learn of someone's immigration status, but by writing it down and by sharing that information, either intentionally or unintentionally, that's another way that it can lead to ICE arrests, especially in the Pittsburgh area. And so being intentional about what information is collected and then who has access to that information, and data sharing, especially with technology changing all the time. That's another thing that we're concerned about is writing it down and then figuring out where that information goes.
Well, can you all think of any circumstance or situation where a magistrate or a judge would need to know the immigration status of a participant in litigation?
The only thing I would say is that victims of certain crimes in the United States are eligible for what's called a U visa, which is a pathway to a legal status for victims of crime in the United States. And in order to get that, they need to collaborate with the legal system. And if they're witnesses, they have to give testimony and they have to show up to court. And they should be informed about their right for that status. But our policy at Casa San José is that you can give someone the information, whether it applies to them or not, and they can decide if, they know if they're documented or undocumented, and they can decide to use that information or not. And so I think sometimes different entities in the legal system, in the criminal justice system, think, well, I need to know if they're undocumented to see if they're eligible for the U visa. But that's not the case. You don't need to know if they're eligible for a U visa. Give them the information and they'll figure it out themselves.
Yeah.
So you think it would be helpful to have the victim center or the victim's advocate who shows up from the victim center give every single, victim. And I think I just read something today that people prefer survivor of crime rather than victim of a crime. So I'm working on trying to use that term, but maybe they should give survivors of crime every single one information about obtaining a U visa. And if you're not an undocumented person, you just throw it away.
Yeah. That sounds like a form that ought to sit at a table for the taking by anybody who walks into a magistrate's office to testify as a victim.
And in various languages.
Absolutely.
There are a
Thank you so
couple
much.
good candidates working on language access in the courts. I believe Lisa's on the platform with one of them.
Yeah, Nicola Henry Taylor,
Yeah.
very interested. She's done a lot of work with the immigrant population, and she is an immigrant herself. So that is a cause that's very dear to her.
Yeah, and I think like I started my civil practice in Philadelphia County and the surrounding counties in 2004, and back then all civil notices were in 2 languages, and the fact that they're still not mandated to at least be in Spanish in most counties in the Commonwealth today is just staggeringly behind the times.
Yeah, sending out notices that someone has to appear in court. I received text messages with pictures of English language documents saying that they legally have to comply with things from courts, and they have no idea because they're in English. And so like language access, like just that can lead to jail for our community.
Yeah.
Moving on, we can bounce over. I know, Lisa, when we've talked a lot, I've heard you talk about jury pools and, a lot of your problems with jury pools. So in terms of just the process of picking a jury pool, can you kind of explain it just so we can kind of, give a background? We always like to give a background to the group in case, people watching aren't, familiar with the process. How does a jury pool get picked?
Okay, so for the lawyers and the litigants, you walk into a room to pick your jury, and there's a room full of people. And a lot of folks don't know how those people get there. So the jury commission basically takes lists, and they can be any type of list where you can document a person's, address and name, address, and how to get in touch with them. And they use these lists to randomly select people from the lists and then send them notices that they're to come for jury duty. Unfortunately, there are a couple of problems. One is that African-American folks are and have been for the entirety of my career underrepresented in the panel of folks that show up from which lawyers pick juries. I commissioned a study actually in 2001. I hired a statistician / lawyer from the University of Pittsburgh, a guy named Dr. John Carnes. And he actually analyzed data from questionnaires that we put together to give to each person who showed up for jury duty for about 6 months in 2001. And what he found was that although African Americans made up about 10.7% of the population of Allegheny County at that time, the percentage of African Americans who were actually present in the jury room was only 4.87%, which means that from the very beginning, from walking into the room to select your jury, over half of the African Americans who were eligible for jury duty were excluded from that service. So frequently you would go to select a jury and you'd see a sea of white people, which is particularly bad in a case where your client is African American and everybody else in the room is white. And it's also just bad no matter what the races of the participants are, because the whole idea of a jury is that you're supposed to get the unique perspectives of all different kinds of people in the community. So whether they're all rich, whether they're all poor, whether they're all white or all Black, it's wrong when you don't have that unique and diverse combination of thoughts and ideas that will lead people to the correct decision. So in response to this study, we presented it in a number of homicide cases, and some judges were kind enough to say, well, you know what, if you walk into the room and the jury pool does not look like representative of the composition of Allegheny, the racial composition of Allegheny County, stop picking, we'll pick another day when the pool looks the way it should look. I used to file motions to ensure a representative sample so that the judge would take whatever steps he had to take to make sure that the panel reflected the community. And those were largely ignored or denied. But back in 2002, the jury commission did try to take some steps to make sure that people came to court for their jury summons. They followed up with phone calls when people didn't appear and things like that. But we're still using the same lists that we were using 20 years ago that exclude people. When you use driver's license or car registration lists, you're limiting yourself to people who A, can afford a car, or B, need a car. If you live in the city and you have access to public transportation, which the city has a higher percentage of African American, Latino, it's a more homogenous, homogenous, is that the right word? Yes, group. No, it's the other opposite. It's a more
Diverse.
Thank you, more diverse group of people in the city. You're excluding those people because the suburban people are the ones who need the cars. So there's no reason why we can't expand to use other lists like unemployment lists or state income tax lists or real estate lists or I don't know, public assistance lists. Maybe you get some people of a different socioeconomic status than the usual group. So there are many other ways. We just have to put pressure on the jury commissions to make these changes and the Supreme Court.
So I hear words like, you present motions, to have the study considered, for jury pool and things like that. So to me, it seems like, when it comes to things like composition of jury pools, that a judge might have some discretion in what a jury pool composition might look like. If I'm a voter, I might be thinking about that when we're trying to elect judges right now. So does a judge have, what role can a judge play in, the composition of a jury pool?
Well, I have had judges, like I mentioned, if we would walk into the room and there wasn't what I consider to be an even adequate representation of the community in the room, we would go up and say to the judge, Judge, it's a sea of white. Can we pick another day? And some of the judges would actually say, you know what, you're right. That's not fair that you would have to pick a jury from a group that is not diverse and representing everybody. Some judges would say no, that you get what you get. I've actually had, I have walked into the room prior to getting my list of who was on the jury and seen that, okay, there are only 5 people out of 100 people in this room that are African American. And so I've gone to the courtroom and said, Judge, can you please direct the jury, the folks in the jury room, to include the African-American people in my jury panel, even though that involves cherry picking a little bit so that we can ensure a representative sample. So judges can do all kinds, I'm not sure if that's 100% according to any particular rule of procedure or evidence, not evidence, but a rule of procedure, but judges they have a lot of discretion to make sure that the juries that are selected are fair and representative, and I think it's their responsibility.
Okay.
I imagine though, Lisa, as I think about that whole idea of picking another day, if you've got a defendant waiting in jail for trial, that's a tough calculation to make, right? The delay of waiting for a more representative jury pool versus additional days in jail waiting for trial.
Well,
And you shouldn't have to choose, is the point I'm making about that.
Well, at that point, you're choosing between two constitutional rights, aren't you? You're
Yeah.
choosing your right to a speedy trial and your right to a trial by jury. And
Mhm.
it seems to me that we do that a lot to people,
Yeah.
you can have a hearing, but we're going to have to postpone the case if you actually want to have a hearing, so you're choosing between your right to a fair trial and a right to have a speedy trial.
Now, based on what I'm hearing, these lists might be comprised of driver's license, registrations, and things like that. Laura, I'm assuming your community might not really be too representative on these jury pools either.
Yeah, in Pennsylvania, you need a social security number to get a driver's license, something we're trying to change.
And are jury summons sent in any language other than English? I haven't seen one in a while.
That I don't know.
I do not believe so.
Yeah. There's another instance where one simple change could make things a little clearer.
Right. And although you may not, since the trials are conducted in English, you may not, if you're not comfortable enough with the language to actually sit on a jury, that's one thing. But the very fact that you could be penalized with a contempt for not showing up for jury duty is why the summons should be in many languages.
Mm-hmm.
Yeah, and since we're on language access, another thing that I see in courts a lot, especially in magisterial district courts, is a judge will ask, are you okay with not using interpretation? And that's a yes/no question to someone that is in an uncomfortable and stressed situation. And I've seen our community members saying, I'm okay, like yes, indicating that they're okay with not having interpretation because maybe the interpreter is running late. And then they're immediately at a disadvantage.
Mm-hmm.
And so by making that a yes/no question to someone that's in a compromised situation is just not good practice that we see over and over again.
Yeah, and it's not as, we know the statistics bear out that magistrates' dockets are not generally busy enough that they couldn't wait a little bit for the interpreter to be available.
As far as, putting like things like warrants or summonses or things like that in different languages, I'm from Texas, and it's very common to have, we have English, Spanish, and Vietnamese, and I haven't been there in a while, so they might have added another language. So you have a much more populous state that has a much more diverse population, and they're able to do it. So there's really no excuse why Pennsylvania can't do that.
Yep.
All right. Moving on now to bail requests. And we know cash bail is a big one, but just in terms of just the general bail request, what would be the role of the district attorney's office? Again, giving some background when it comes to making that bail request. Usually, we can do both levels.
Okay, so usually they don't get involved in the initial arrest unless it's a very serious and notorious case. They usually don't get involved. When a person is arrested and they go through the processing at the county jail, they're interviewed by people from the bail, what used to be called the bail agency, now it's called pretrial services. They do an assessment, a risk assessment, and then they go in front of a magistrate and the magistrate will set the bail. The problem is, so they don't have anything to do with the original. The problem, and certainly would defer to Hilary talking about this, but some of the risk assessments that they use are problematic in that there's an inherent racial bias in them. And so you have to be really careful when you're using those types of risk assessments. Originally, they started using risk assessments because they saw that judges were not giving people fair bail. In other words, they were releasing Black people less, they were giving Black people higher bails. And so they said, well, how can we even this out? How can we make this fair? We'll just make it a statistical analysis. And so there won't be any racial inequity at all because it'll just be a piece of paper. Unfortunately, it's inherently biased just because it considers things like, and to go back to what you said, like way back at the beginning, how many times have you been arrested?
Mm-hmm.
And that makes you a higher risk. Well, if you come from a community that's heavily policed, and those are communities of color, you're going to have a higher number on that. It doesn't take into account the charges, like robbery can be pushing past a security guard on your way out of, stealing a pack of gum from the Rite Aid, or it could be pointing a gun at, a pregnant woman's face in the shoe store. But they're both robbery, and that's all the risk assessment, considers. So you have to be careful when you're looking at those, and I'll defer to Hilary talking about.
Yeah, Lisa, we talked a little bit about that last Monday, that kind of the algorithm and the statistical analysis with Giuseppe Roselli last week. The whole idea of an algorithm is great, but if you put bad data in to create the tool, you're going to get bad data out.
Right.
And I read an article that was based on a study in a law review article, the title of which is "Virtually No One is Dangerous Enough to Justify Jail." And I think all too often this threat to the community or risk to the community is an inappropriate excuse to deny bail or to make bail so exorbitantly high that people are stuck in jail awaiting trial.
Yeah, I think the exception to that might be domestic violence cases.
Right.
And a lot of times if you can ensure that the individual has another place to stay, or then you don't need to keep those folks incarcerated either.
Right. Yeah, because the whole idea of threat is not threat of what already happened, but preventing future harm.
Right.
And so if you can create conditions that minimize or mitigate that risk of future harm, there are very few crimes or alleged or accused defendants whose conduct justifies denial of bail, even if the algorithm might suggest otherwise.
Right. And part of the problem, I think, with cash bail is that most of the judges that set high cash bails are really denying bail, right?
Mm-hmm.
The Constitution allows only under very, specific circumstances. The fear that some people have, and I am for eliminating cash bail. I think the options should be release, no release, or release with conditions. And the no release is only if somebody is an imminent threat either to another person or to the community. Like money shouldn't have anything to do with it. The fear is that magistrates who currently set very high bonds in hopes that people won't make the bail will, under those circumstances where cash bail is gone, will just deny bail. And so that's the one downfall to eliminating cash bail, as far as I'm concerned, is that some magistrates may say, well, if I can't set a $75,000 straight bail for this guy, I'm just going to deny it entirely. And that's my concern. I know you will not do that.
No, absolutely not. I can't imagine a circumstance where it would be safe to let someone out just because they can pay $75,000. Like either they are not a risk and they're not a flight risk, or we can get their passport and keep them from fleeing the jurisdiction, whatever, or they're not. And it shouldn't be because they can or cannot afford a $75,000 cash bail or $1 million bond or whatever.
And the only people who really benefited from that system have been bail bondsmen, right? Because
Yeah,
your child is in jail and they want $25,000 to get him out, and you don't have $25,000, you will go to see whoever you can to scrape up enough money to pay a bail bondsman, and you don't get that money back.
right.
So I have $25,000 or $75,000 sitting in my like little basket back there that I can down to, you know, the jail and get my child out of jail. And when their case is over, I get my money back because I'm rich. I had it and I get my money back. If you are poor enough to scrape it together, you pay the bondsman and that's his fee. So you don't get it back. So it's
And in the meantime, your child who's waited for you to get to the bail bondsman with that money has missed several days of work and is probably getting fired from their job and then can't support their family. And it's just this cascade of consequences because of a unnecessary bail decision.
right.
Well, and another thing is that bondsmen require proof of income and collateral. And so with the undocumented community and immigrants, they often don't have that, which means that even if it is something that a bondsman could pay, our community is often excluded from that.
Mm-hmm.
Another thing I wanted to say that is things that we've seen is that police officers often just put down all potential charges for a crime. And then if a judge sees like a certain level, they're obligated to set like to do certain things. And so police officers will just put as many charges as possible to see which ones stick. And that actually affects the bond and the decision of the judge. And so like what can judges do given that that is a practice that I've seen used widely with police officers?
They can read the affidavit that's attached to the criminal complaint. You know, every time, you know, you file an arrest or you file a criminal complaint against somebody, you have to, you list the charges, but you also list why you believe that this person should be arrested. And frequently a judge should, or judges should read that carefully when setting bond. Because like I said, it makes a difference whether the robbery is a gun to the head of a pregnant lady in a shoe store or a 17-year-old who brushed by the security guard, you know, stealing the gum. So
yeah, I mean, the whole idea of overcharging to make bail or bond less likely just seems like another instance where a little bit of skepticism on the part of the information put in the affidavit is a good practice.
At what stage of proceedings are then charges able to be reduced?
that's Hilary. That's where
Is it
Hilary,
right off the bat?
Yeah, it can start at the magistrate.
and should.
Yeah. Especially when you know police departments might have a habit of overcharging for some of the reasons Laura just talked about. Yeah, I mean, magistrates can and should, you know, take an active role in analyzing the charges that have been presented and determining whether or not there's evidence of all of those charges. And if not, ought to get rid of the ones where the probable cause and the evidence doesn't exist before it gets kicked up to the county.
So again, looking at magistrates who are going to be reviewing the affidavits, and rather than just in the traditional kick the case, you know, up to the common pleas, is something us voters should be most certainly paying attention to.
Yeah, I don't think we want magistrates who are rubber stamping the activities of our police officers. That's not their job.
You know what's interesting is I did hear one of the candidates for Court of Common Pleas talk about, you know, this is their suggestion on how to reform the court system. And they said, we should have community courts. We should bring the courts to the community. And I just did like one of these because I thought, we have those. They're called magistrates. You know,
I think that's what I'm running to be.
right. So I think a magistrate and somebody who's sensible and has common sense and understands the system and understands the law, somebody like Hilary could make a huge difference, because she could evaluate not just, is there enough evidence to hold this case for court, but can we do something else with it other than just send it up, to common pleas court? Can we be involved in some restorative justice process? Can we do some sort of mediation? Is there a way to pay restitution, to make people whole, so that this case can be resolved in a community court where the judge knows, the area, knows the people. So we do have.
Yeah, I mean, there is a small segment of the, criminal code that can be determined and resolved by way of pleas and resolutions at the magistrate level. And, if a magistrate takes a fine tooth comb to that list of what might appear to be excessive charges and kicks all the big ones out, we reduce the charges, and we can reduce the backlog in the Court of Common Pleas and shorten the delay for the people whose charges belong there, shorten the time they're spending waiting for their trials. And that's the whole, the whole design of our court system is that the courts at the bottom hear the most cases so that we filter up, and the bigger ones and the more consequential ones are heard at higher levels. And if magistrates are just rubber stamping every single charge that comes before their court, they are not doing their role in being a filter.
Part of the problem too is that the district attorney's office frequently sends people with less experience to the magistrates' courts, and therefore they don't have either the knowledge or they're not given the discretion to reduce charges. I'll never forget a gun case I had where the guy accidentally answered one of the questions wrong on the form, that you fill out when you want to buy a gun. The detective knew it and acknowledged it and said, yes, this should be, this will get thrown out. The DA said, yeah, I get it. It'll probably be thrown out. The magistrate said, yeah, I get it. It should probably be thrown out. And it was held for court because nobody had the courage to say, well, let's just throw this out now. And so my client had 3 more court appearances with 3 more missed days of work and all those many more months of having a criminal charge looming over his head before his case was thrown out. So it will be nice to have a magistrate who is not intimidated by the police or the district attorney, who makes independent decisions on their own.
Yeah.
I have a few miscellaneous questions we want to ask. One of the other criminal justice reform recommendations listed in that report, cited in the article, is to end arrests for low-level offenses. So since we obviously cannot change the criminal statute, and magistrates and judges are required to uphold the law, is there a role judges and magistrates can play when it comes to low-level arrests, marijuana possession, for example, that come before you that could improve conditions for the Black and Brown communities that are most affected?
Yeah, I think there's a role to play. Lisa, do you want to talk about any of your experience so far in that?
Well, I think the greatest role would be the district attorney if they would take that role. There was just a report that came out from, where's she, in Baltimore, where the district attorney, because
I saw that.
Yep, because of COVID, she said, I'm not prosecuting these low-level misdemeanors. I'm not prosecuting possession. I'm not prosecuting any of this stuff. Violent crime went down by like 30% over, and this wasn't just a day or a month, it was a year. Over the course of a year, by not prosecuting these nonsensical crimes, by all these, burglaries, crimes against people, they all went down. And we need a courageous district attorney to do that. Hopefully we'll find one in the next couple of years. That we have a couple of years to locate that person. I think you can make it worth. Judges can do all kinds of things. Right now we have a lot of police officers who are subpoenaed to appear in hearings in common pleas court that are either unnecessary or B, are re-subpoenaed over and over and over for cases that are not going to trial that day. District attorneys are the ones who sign off on these subpoenas, and then the officer takes them and gets paid for their appearance.
And they get paid overtime, right?
They can get
Some
paid.
officers in some jurisdictions.
Yeah, and at municipal court, when I first started, there was a guy, Ron Nagy, he was a police officer. He drove this giant, you have to remember, this was the late 80s, like giant Eldorado that he had bought with all of his overtime. Because
Mhm.
he was just an old guy. He would not make anything but a garbage arrest. I mean, he arrested people who were peeing on the street or, whatever, because he didn't want to go to court. Like, he didn't really want to go to court. He wanted to go in front of the magistrate, and he would schedule his hearings for his off days. So he'd get time and a half sitting around waiting. He would
Mhm.
reduce the charges on every case down to some summary offense so that he didn't have to go to court, and he made a fortune. But Pittsburgh Municipal Court has stopped that practice. So they schedule police when they're actually on the clock.
Okay.
But they don't have that liberty up in the Court of Common Pleas, because that's all of the police jurisdictions.
Mhm.
So, I think that judges could interject themselves into that payment process. Like, why are we paying people to come to court? And if you stop paying police to come to court on nonsensical cases, they may stop bringing the charges. Or,
Mhm.
if a person is convicted of a possession of a marijuana case, instead of giving them a year probation, you could give them a day probation. I mean, there are all kinds of different ways to let people know you're not going to benefit from prosecuting these cases.
Yeah.
And I think probably at the magistrate's office, you might have a little bit more leeway in terms of you're influencing various outcomes,
Right.
you know.
Yeah, for sure.
I know this has been something we've been touching on all night, and Lisa, you just kind of mentioned it about the district attorney. So over the weekend, it was announced that Philly's district attorney, Larry Krasner, did not receive the endorsement of the Democratic Committee, even though he's the incumbent. And then there's been a long tradition, 45 years, of endorsing the incumbent. And since DA Krasner was known as a criminal reform DA, he helped reduce jail population, reduce time of probation, and worked to hold the police accountable. In light of these developments, what do you think, Lisa? What do you think this says about where the best elected positions are to make real and lasting change?
I think that a district attorney's office is a very good place to make change. The problem is, however, that it's a 4-year change. It's not long lasting. So, when you are a prosecutor who is basically trying to change the focus of the criminal justice system from being punitive and pro-incarceration to being one that is restorative and reformative, you're gonna butt heads with people along the way. And Larry Krasner has butted heads with the police and the FOP along the way. And so 4 years later now, or 3 years later, when he has to run again, they're opposing him because they don't like that he's taken their autonomy away and that he's making decisions about what cases are prosecuted. And he's, changing the focus from what the police want in incarceration to what's best for the communities and what do the people need. So in terms of lasting change, sometimes judicial offices are the best place to make lasting change. Magistrate's term is 6 years. Am I right, Hilary?
Yeah.
And a common pleas judge term is 10 years. And you may not be retained, you may not be reelected, but at least the community would have the opportunity to see what the changes that your policies have made and give them enough time to actually take hold and bear fruit, so to speak, before you make a judgment. I think judgments are being made on Larry Krasner before we've had an adequate opportunity to see if his policies really are making a difference.
Yeah, I mean, it doesn't seem to me that 4 years is enough time to reform a system that is designed to be is designed to punish poverty and punish being a minority. There are just so many things about our system that are working as designed by the designers of the system that you need a lot of time to fix. 4 years isn't enough time. Maybe 10 years isn't enough time, but you got to start. And you can start, if you put a bunch of new reform-minded judges on the bench all at the same time with 10 years runway, think about, that's a huge opportunity for some impact in the courts.
Which is the perfect opportunity to plug you guys. So you guys are, let me see, oh man, and I'm not going to be able to plug your camp. Let me see if I can get the chat up. I think it's still in here.
Mm-hmm.
Oh nope, did it disappear? Let me type it in. We have Hilary's campaign. Hilary, why don't you tell us what you have coming up?
Well, I'll be here every Monday night for the next 6 weeks, having these important conversations with Court of Common Pleas candidates. We'll be canvassing every weekend, lots of weeknights. And I'm joining Tiffany Sizemore for another Court of Common Pleas candidate for a meet and greet on Thursday. So that's like immediate what's on the docket.
All right. And Lisa, what do you have coming up?
You know what? You said that and I was like, well, I don't know.
I know, I blanked a little bit there, Lisa.
No, I just look every day and go where I'm supposed to go. But I actually have, and you'd have to look on my website, but I have a meet and greet hosted by Marianne Raymer on April 5th at 7:30. It's supposed to be Who Says Judges Can't Be Funny, or Who Says Lawyers Aren't Funny. So that might be an interesting thing to go to. We're always, every weekend we also have a canvas. You can check my website out. I go to all of them. I think that if you want to be elected to an office, you need to walk the street and ask people to vote for you, get to know you, hear what you have to say. So I believe our next canvas is on Saturday, but not Sunday because Sunday is Easter. And then that is in Bloomfield or in the city. And I'm not sure where the one after that is. I would have to check my very own website to find out where that is.
We only pay attention like 1 week at a time.
Right.
Well, your websites are both up there. So people can punch them to go to find these events. And obviously we are advocacy groups. So we want people to donate to your organizations. And Laura, this is your opportunity. You said you were mentioning a initiative to help get driver's licenses not to have social security numbers attached to them. And I put up accidentally the wrong website for Casa San Jose. It's the org one. It's not the COM, sorry. But here's, why don't you go ahead and plug that?
Yeah, so we have a statewide coalition called Driving PA Forward, which is a group of really anyone that believes that the right to get a driver's license and ID should be restored to folks that don't have social security numbers. And just keeping in mind that you don't just use driver's licenses to drive, which should be a human right. You also use it to pick up your kids from school, and you also use it to get a bank account. And so it really does affect the lives of our community members. So if you'd like to get involved, just search Driving PA Forward, follow Casa San Jose on social media, and contact your state representatives about that.
And Laura, does that social security number requirement also apply to just the state photo identification that is not a driver's license?
Yeah, because it's also through the Department of Motor Vehicles,
Yeah.
unfortunately.
Okay. Yeah, that's especially problematic. Okay.
Great. All right, everyone. Thank you.
Thank
For
you.
tonight, I'm going to turn everything off Facebook now.
Thank you.
Oh, and next
Thank you.
week, we'll be back next week. Sorry, I almost forgot the plug for next week. We'll be back next week with Nicola Henry Taylor, Hilary Wheatley Taylor, and Tim Grealish, who is a placement specialist and substance abuse counselor and interventionist who works with the magisterial courts in the South Hills and Washington County.
Thanks for joining us, everybody.